Excited Utterance, the Evidence and Proof Podcast, Episode 155, Richard Friedman, A Proposal to Replace the Hearsay Rules. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Rich Friedman. Rich is the Aileen and Alan F. Smith Professor of Law at the University of Michigan Law School, where he teaches evidence, civil procedure, and a seminar on sports and games as legal systems. Rich, of course, is best known for his work on the Confrontation Clause, having developed the idea of testimonial hearsay that was ultimately adopted by the Supreme Court in the seminal case of Crawford v. Washington. Our podcast today features Rich's new article, A Proposal to Replace the Hearsay Rules, which is forthcoming in the University of Michigan Journal of Law Reform. In it, Rich explores the possibility of reconceptualizing and restructuring the hearsay rule around the idea of testimonial hearsay. The hearsay rule, as most lawyers can attest, is a labyrinth of complicated definitions and exceptions. And at the end of the day, it's not even clear that it does all that much, given that psychological studies have shown that people do in fact downweight hearsay. Scholars have suggested various simplification schemes from time to time, often centering on the exceptions. Rich, by contrast, suggests making only testimonial hearsay inadmissible, with testimonial defined largely through the Supreme Court's recent Confrontation Clause jurisprudence, with some additions or amendments. The result is a significantly simplified hearsay rule with not a lot of exceptions, although one that's not without some quirks and wrinkles that are worth exploring. My discussion with Rich explores his proposal, the relationship between hearsay and confrontation, and just perhaps the future of the hearsay rule. Rich, delighted to finally have you on Excited Utterance. Welcome.
Thank you. I'm very happy to be here. Thanks for inviting me.
You've, of course, spent much of your career thinking about hearsay, confrontation, and the relationship between the two ideas, most famously leading the charge in Crawford v. Washington. Now that I've finally gotten you onto the podcast, I'd love to hear a short origin story. So, where did the interest come from, and why does confrontation captivate you so?
So a long time ago, I started a major research project on the law of hearsay, which I've not yet published, but there's still time. And I started digging into the history, and it was very interesting as I did when I went back to old treatises. I found there was not a lot of talk about hearsay, but there's a lot of talk about witnesses, and that helped me put together a thought that had been rolling around in my head, that the confrontation right, as it's expressed in the Sixth Amendment, is not a constitutionalization of the law of hearsay. It's a rule about how witnesses must testify. And the more work I did that confirmed that, and I've done a lot of work now with an English legal historian, Mike McNair, that's also not published yet, but we're on the way. And I'm convinced that the confrontation principle, the idea that to testify, you have to do so in front of the adverse party under oath and subject to cross-examination. I'm convinced that developed long before the hearsay rule as such, and that the hearsay rule in all its breadth and with all its exceptions and warts and all that kind of occluded the confrontation right. And I think that most of the law of hearsay is not worth very much, but the confrontation principle at its core is. So trying to disentangle that became a major interest of mine. And when you say led the charge in Crawford, I mean, I was involved academically. Crawford was not my case. I was second chair to Jeff Fisher and an amicus, but I was there at the creation.
So obviously you're right on that on a technical basis, but I think that many of your ideas are what ended up being in the Crawford decision. And what an interesting story about how, as most good academic stories are like, you went in looking for one thing and you came out seeing something else. Let me move to your paper. So your paper is about hearsay. It offers a proposal for restructuring and reconceptualizing hearsay, much along the lines that you've been talking about in your journey. Let's step back for a minute and just talk about what's wrong with hearsay as it currently stands.
All right. I think there are a lot of things that are wrong. First of all, I think most hearsay is actually pretty decent evidence in the sense that it's more probative than prejudicial, assuming that live testimony by the declarant to the same proposition would be. And the idea that's been spouted for many years that the jury would overvalue it and overvalue it by so much that it would do more harm than good to let it in is just not supported by such empirical evidence as there is. In fact, it appears that jurors do tend to discount the value of hearsay. So, and then it adds to the expense of litigation because sometimes it requires the parties to present live testimony, even though the proponent would be perfectly satisfied to present the cheaper hearsay, and the adjudicative system would be well enough served. And then there's an enormous amount of litigation effort. I think beyond that, it complicates things. It rests on perceptions that are dubious, sort of cracker barrel psychology. It's complex. It requires us to teach things that just don't make an awful lot of sense. It doesn't get any respect. And the reason the rule of hearsay doesn't get any respect is because it doesn't warrant respect.
So, how would you like to reframe it? So, in your paper, of course, you have a complicated textual rule that you propose, and we can't necessarily dissect it line by line, but maybe you can summarize the core ideas behind that proposed change.
I don't think it's all that complicated. I think it's a lot less complicated than the law we've got. I mean, I stated in about a third as many words, and it's a lot less sort of rule based. But at the core is the idea that if a statement is testimonial, and I would define testimonial in an objective sense as it made with an expectation or in certain circumstances in which a reasonable person in that situation would realize that there's a substantial probability that it would be used in litigation concerning the occurrence that it's talking about, right? In rough terms. If a statement is testimonial, then it's presumptively inadmissible. And this is even apart from the confrontation clause. I think that core idea is correct. We want witnesses testifying face to face under oath subject to cross-examination. And then there are a few qualifications. If the witness testifies at trial in accordance with the prior statement, then perhaps the prior statement should be admissible. If the witness is unavailable at the current proceeding and the opponent has had an adequate opportunity to cross-examine, then the prior statement can come in even though it's testimonial. If the opponent forfeited the right or forfeited the objection by rendering the witness unavailable by serious misconduct that was predictably going to achieve that result, then that would be another reason. And I also wrote into my proposal a notice and comment provision, an objection provision that if the proponent gives notice, then the opponent has to file an objection by a given date or else it's okay. I've also got one extra procedural curlicue that I offer as a possibility. And I don't know if you want to get into that. That does get a little more complex, but that's the main part of the rule of the system that I propose.
So, we have a few exceptions, but it's a very small number, and then no more 30 or 40 exceptions, depending on how you count them, in the regular hearsay rule.
That's right. It's a narrow exclusionary rule, only applying to testimonial statements and with fewer qualifications or exceptions. And the rest would be left, as most evidentiary decisions are, to the discretion of the trial court. it's kind of curious that we are willing to let most evidentiary decisions be made on a discretionary basis. In this context, we're not. And I'm saying, if it's not a testimonial statement, then it should be presumptively admissible like most evidence and left to discretion, which can depend on various considerations.
So one question here, you're obviously basing hearsay largely from ideas from the Confrontation Clause jurisprudence that has surfaced since Crawford. Confrontation is a criminal doctrine. Your proposed rule and the hearsay rule generally applies across criminal and civil cases. Any thoughts about that divide? Why keep hearsay in civil cases at all? You talk about how in other jurisdictions around the world, hearsay is just simply abolished in civil cases.
So I think that with respect to testimonial statements, with respect to testimony, I think the presumption should be that the witness testifies at trial. Now, we could go to a different system. We could go to a system in which witnesses can just testify by affidavit, and that's enough in a civil case. I think we'd probably be unhappy with that. I think it goes against the grain to do that. But notice, I mean, if you wiped out the hearsay rule altogether, then that would be the consequence, that it would be the proponent's decision whether to present a live witness or just to present an affidavit. And I think, at least for now, I'd say that it's better to say, as a presumptive matter, present the live witness. But if the witness is unavailable and there's been cross-examination, and that's something, if you've given notice and the other side hasn't objected, that's okay. I also throw in the possibility in a civil case that the proponent can say, look, you're in as good a position, opponent, as I am to present the declarant as a witness. I'm telling you I want to use this statement. The court's satisfied. It's more probative than prejudicial. Opponent, if you want to bring the declarant in, okay, I'll put the declarant on the stand, but it's up to you. So I think that achieves a good balance, because that puts the opponent in the position of saying, is it really worth it to bring the declarant in? But notice what it also does is, if the opponent says, yes, it's worth the cost, it's the proponent who has to put the declarant on the stand, not the opponent, because opponents virtually never call a hearsay declarant who's made a statement offered by the proponent in. So it makes things smoother that way. So, I think that most hearsay would get in civil cases, but I don't want to have trial by affidavit.
One other thought that occurred to me while reading your proposed rule is that it still includes, at least for students, the dreaded truth of the matter asserted definition in it, which is obviously the source of lots of complexity. Thoughts on why we should keep that assertion-based definition? I think that there have been at times in our history that people have thought about or proposed or even applied a declarant-based definition that's not based on assertions. Why should we keep that language? Why shouldn't we just simply drop it?
Well, that's interesting. I mean, I guess I buy the idea of Tennessee v. Street, which said even in the confrontation context, if you're introducing prior testimonial statement, confession, but you're not asking the jury, the trier of fact, to accept it as the truth, then we don't have the same problems that we would otherwise. The confrontation principle is really aimed where somebody is testifying and the proponent is saying, believe this fact because this witness testified to it. Well, if you're going to do that, then it ought to be in front of the adverse party. I do want to say that you'll notice that I don't have any definition of statement, because I don't think we need it. The general principles that I enunciate would apply to hearsay as currently defined, and also to conduct offered to prove the truth of an apparently implicit belief, as in Wright v. Tatum, the famous letters case, or the shipboard captain hypothetical. We don't have to worry about the distinction between a statement and a non-statement. With respect to testimony, testimony is essentially always in this statement. I think that's what testimony is. It's an assertion of a proposition. Where it's a concern is when it's being used to prove the truth of that proposition. So I think you're right that as I've conceptualized it, it would still require that line between offered for the truth and not. But one thing I want to emphasize is that I think that with respect to testimonial statements, that arises much less frequently than it does in other contexts. In other words, a Tennessee v. Street type of situation is relatively rare. Usually, when a proponent offers testimony, it's offered to prove the truth of that testimony. So I think it becomes that line becomes much less important, and other lines wash away. And hey, if you want to expand for whatever purpose the testimony shouldn't be used, but basically overrule Tennessee v. Street, it wouldn't undercut the basic idea of my proposal, I don't think.
Before we end the podcast, or before I get to my final question, I did want to make sure that we didn't neglect one interesting feature that you added to your group of proposed rules, which was your proposed 804, which now becomes a child competency rule. Tell us a little bit more about that and why I think you decided to structure it as a competency rule rather than as some other structure.
Well, I guess it's in part a competency rule. So I've been distressed over the years, reading transcripts of cross examinations of very young children. And, I think, oh my goodness, what is this accomplishing? And then, I see the statements that the child made out of court, and I think, well, was the child testifying? And so I think, is this just the wrong approach, to deal with it in the same under the same rubric as we deal with adults? So I did work with one of the great developmental psychologists in the world, Steve Ceci of Cornell, and we agreed that very young children, and you can debate the age, but I think Steve would say before they've developed a theory of mind, they don't have a sense of the gravitas of their statements, and I'll use the word solemnity. So I think their statements just shouldn't be considered testifying, and we should be thinking about them in an altogether different way. So they are nevertheless sources of evidence. I mean, what the child says may be very important and may be very probative. So they are sources of evidence in the way that there are many other sources of evidence. And I'm not denying the child's humanity. I've had 3 kids, and they're all human beings. They were as soon as they emerged from the womb, but that doesn't mean that they have to be treated like adults. So the proposal really is to say, okay, there's sources of evidence, which means the other side has a right to examine them. But that examination does not necessarily mean cross-examination by a lawyer in court. The examination would be much more sensible if it was done by a qualified forensic investigator according to a protocol that is established by law. And that's the proposal for children under whatever level the particular jurisdiction would choose. I think the world would be much improved if that happened. At least this little corner of the world. I think defendants would have more effective rights. I think there'd be less trauma for children. I think the judicial system would operate better.
Yeah, it's a fascinating proposal, especially because it ties so well with your theory of testimonial hearsay. Once you focus on testimony, then you can ask yourself whether or not these really young children are truly giving testimony in the way that we think of testimony as being testimony. And then you can just exclude them entirely from those kinds of requirements. So it's a very elegant move and an interesting one, given that, it just sort of fits in very nicely.
Well, thank you. Can I just plug the piece in which we
Please.
first enunciated it? It's a piece in the University of Chicago Law Review 2015 called The Child Quasi-Witness by first listed author and then Stephen J. Ceci. And quasi-witness, we use that term because the child isn't really a witness, but is a source of evidence.
Final question for you. And normally, the tradition on Excited Utterance is I ask you, what's next for you with this project? But here, I'm going to deviate a little bit, and I'm going to give you a proposal for what might be next for your project. So, Henry Wong at Florida State and I have been thinking a lot lately about evidentiary rules for administrative contexts. So, contexts where primarily bench trials, no juries, pro se litigants are common. Might that be a practical place to start for your proposal for the reformation of the hearsay rule? It seems to me that when you have pro se litigants, simplifying the hearsay rule becomes super important, and you've accomplished that. When you have a bench trial, you can worry a bit less about trying to manage the jury and just focus on the legitimacy aspects of the hearsay rule, which again is something that I think your definition captures. So it seems to me that that might be where you should go next.
Well, maybe. I'm grateful for any suggestions. So you're talking about administrative proceedings where they do follow the rules of evidence or purport to?
Yeah, it turns out that many workers' compensation courts, for example, have recently begun imposing the rules of evidence. Or actually, I should say, legislatures have started to impose the rules of evidence on things like workers' compensation courts, somewhat paradoxically or strangely, but that's true. And the judges have a lot of trouble dealing with it because the litigants don't know anything about these complex rules.
Well, that's a very interesting possibility. I'll tell you, I think Crawford effectuated quite a large change, and it was relatively easy in that only 5 people had to be persuaded, and 7 were. Legislative change is much harder. So what I've been thinking is that if I can get a state Supreme Court there's some states in which the state Supreme Courts control the evidentiary rules, and that might be the best shot. But you're right that administrative proceedings might be regarded as sort of a lower risk forum. I will take whatever possibilities I can get. I'm grateful for the chance to appear on this podcast to give this work and the proposal a little bit more publicity. I should say that it's going to be published in the University of Michigan Journal of Law Reform, I believe, this month, and I would love people to pay attention to it. And obviously, they might not adopt my proposal hook, line, and sinker, but to move in the general direction. And it seems to be a massive change. I mean, we should bear in mind, as you mentioned at the beginning, that most of the common law world has vastly decreased the role of the rule against hearsay. And I really do believe that Crawford opens up a possibility to do that in a practical way that adheres to the core of traditional principles by separating out the confrontation principle from the rest of the mess of hearsay.
Well, Rich, pleasure to have you on the podcast today. Great having you on the show.
Well, thank you so much. I really do appreciate you inviting me.
The relationship between hearsay and confrontation has certainly had an interesting history. Before the Crawford decision in 2004, the Confrontation Clause was basically defined by hearsay. The Supreme Court's doctrine in Ohio v. Roberts effectively constitutionalized the hearsay rule and its exceptions. Then, in part due to Rich's efforts, the Supreme Court broke this link. Hearsay was its own thing, a rule of evidence, warts and all, and confrontation was its own thing, revolving around this idea of testimonial statements. Rich's idea, in a way, therefore comes full circle. Now, rather than confrontation being defined by hearsay, his proposal tries to define hearsay using ideas from confrontation. I suspect that this was Rich's plan all along, especially now that we've heard the history of his interest in this area. In many ways, basing the hearsay rule off of testimonial hearsay has a great deal of appeal. It eliminates the endless complex exceptions, and in a sense, it goes back to the basic idea behind the hearsay rule. If a witness is going to offer testimony against someone in court, whether that's criminal or civil, that witness should, as a general matter, show up and subject themselves to cross-examination. What about other non-testimonial out-of-court statements? Well, in those cases, we might be frustrated by an inability to test the declarant, but one can usually subpoena the declarant. And if the declarant is not available, it's not really unfair to use the past statement since it wasn't really intended for litigation. It wasn't someone trying to evade giving live testimony. And in these cases, not only is it not unfair, but arguably it's eminently sensible to use the statement since they're not available. Why throw away valuable evidence just because the declarant is now dead or can't be located? As we discussed at the end of the interview, whatever the merits of Rich's proposal for standard trials, I think it holds special promise in other contexts, such as administrative proceedings, which often have a lot of pro se litigants. A simplified hearsay rule that is more intuitive and easier to explain will make these venues less confusing and more accessible to litigants without attorneys. And hopefully, if we get used to the simplified testimonial hearsay rule in these other contexts, perhaps that will open the door for greater hearsay reform in the traditional trial context. Support for Excited Utterance is generously provided by Vanderbilt Law School's Brandstetter Litigation and Dispute Resolution Program and the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Marella. Additional production assistance has been provided by Carmen Wilson, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.